abusia minchia na me akwa basonko so emfa wo emra eye ba media GH so abusia ade a Chief Justice Gertrude Tokunu no petitions miensa ana nkoka eye the office of the president a omo akira His Excellency John Dramani Mahama enhwem na onjina so na onhwe se ensem na ewo mu no edimu a onsake eye Chief Justice na abusia petition ba kon chese aliki ama emunsem aba beda abonten chese melodies ne saka odi aba oridi edi akire ye nsem a ewo eyesa petition ba konim mema mekasa anwa no pese ye kono ekoti nsem a chese ewo sa document na sebie na se ohwa adwenche bia abomode na ache adwuna be hya no nso edi ama yese ha eda so ye be media G so abusan se enane de dika woni twa channel so a bobodi subscribe like na bo ahye ma wo fa pense ne bi eti enya bi entie yanko ne nkoti ensem a chese ewo sa document ni mu a His Excellency John Dramani Mahama says ansem ne de edimu obetumi agina so e de asake Chief Justice yanko ne nkoti ensem a ewo sa document ni emra sesia e hada so e be media GH so yadase
Ghana is interesting. Me mamoti asiye say just as the petition to President Akufo-Addo yeka say only a year Chief Justice Gertrude a year Tokonu a won you no on say sa petition no eliki e ka say sa petition we a asanso abayi sa new petition ya abayi 3 petitions here nam so nti ya form a year prima facie case no me can say enye me wan say petitions no ebe leak and the documents be about bontin a say the alleged petition of one of the group inti ngrofo miensa na petition inti emu baako the petition ene leaky. Now I would want us to go through the petition and see the things and ngrofo no aka enu nti omo say president engineer so na yempami Chief Justice president ne trese prima facie case na trese ensem a yesi won gina so no ensem bi a we hu ne say edimu enti this alleged petition was sent to the president on 14 February 2025 trese Val's Day enti Valentine's Day pam ye sure say na mami one ni kunu ene nebusuafo eji omweni ne no obi send the petition akwa koma president say yin mami free ho as the 14th February 2025 His Excellency the President of the Republic of Ghana, Flagstaff House, Accra. I say, dear Mr. President, I say petition for the removal of the Chief Justice of the Republic of Ghana, Her Ladyship Gertrude Saki Tokonu. Preamble. I say, we the shining stars of Ghana, citizens into group need no shining stars of Ghana. So that's the name of a normal petition president. They call the shining stars of Ghana. I say, we the shining stars of Ghana, citizens of the Republic of Ghana, humbly submit our petition to Your Excellency, the President of the Republic of Ghana, praying for the removal of Her Ladyship Gertrude Saki Tokonu, the Chief Justice of the Republic of Ghana. Our petition is initiated as a result of the Chief Justice's demonstration of 1. Stated misbehavior, incompetence. It's almost a Chief Justice now. You see, no, or more equal from the shining stars of Ghana, no. Yenye Chief Justice because 1 wendini huni 2 wa trese ejuma no on to me nye nti 2 reasons nti a wo si yenyi no. Now it's a legal basis of our petition. I say legally our petition is grounded on Article 1461 of the 1992 Constitution. We've all read Article 1461 and we know what it talks about, right? So I don't want to go deep into that. I mean, Article 1461, we've talked about it on this platform. I've read the whole article, the entire article on both of my platforms. What I say, but let's jump forward because petition is quite lengthy. As a meaning of stated misbehavior, and what trust you say, you can say misbehavior as a trend saying, Natiha, according to Black's Law Dictionary, revised 4th edition 1968, misbehavior means conduct improper or unlawful behavior. Say Chief Justice we any the past Chief Justice in some way omo NDC for in some way go Supreme Court omo say according to Black Dictionary it is Black Dictionary Black's Law Dictionary na nkrofo so use address omo tre the meaning of misbehavior. I say again, with reference to Cambridge Advanced Learners Dictionary, misbehavior means bad behavior. And the first grounds are almost misbehavior. No misbehavior no as a trend saying not as any background saying American when dini huni into no and no mutremu. Law affirm. Now the meaning of incompetence. I say although incompetence is not explicitly defined in the 1992 Constitution of the Republic of Ghana, its meaning is explained by some authorities. Reference from Cambridge Advanced Learners Dictionary indicated that incompetence is lack of ability to do something successfully or as it should be done. Omotre incompetence. Ye kaso bi eye incompetent a ye kan wo twi mu na wate ase atrese nipa kro no wa bon. See obi ye incompetent a simply that's what it means. Wa bon. Ejuma no ntumi nye. Nti eno no mo ka. As a course of action of our petition, the entire woman take a position way. I say act of stated misbehavior by the Chief Justice. The Chief Justice in Yama waye aye trese no hunti trese wendi ni huni ntino yini free hono. I say on 30th May 2024, the Chief Justice of the Republic of Ghana officially wrote a proposal to the then President Nana Addo Dankwa Akufo-Addo to appoint 5 judges to the Supreme Court. In her proposal, she added that I write to respectfully request that the following judges be appointed to the Supreme Court of Ghana. That assemble Chief Justice no a trauma President Akufo-Addo. Eka say 1-4 emra meka ne ho e Supreme Court no. I say the above action taken by the Chief Justice was in breach of Article 144 of the 1992 Constitution of Ghana. It is pertinent to cite the entire provision of Article 144 at this moment. They thus read. Into what I say Chief Justice no catch President Akufo-Addo say 1-4 nkrofo bi mra meka ne ho Supreme Court no. Chief Justice wetia mra na wetia ne Article 144. Into omo kenkan Article 144 na Ghana for yate ase. Article 144 nini. I say the Chief Justice shall be appointed by the President, acting in consultation with the Council of State and with the approval of Parliament. 1442. The other Supreme Court justices shall be appointed by the President, acting on the advice of the Judicial Council in consultation with the Council of State and with the approval of Parliament. 1443. Justices of the Court of Appeal and of the High Court and chairmen of regional tribunals shall be appointed by the President, acting on the advice of Judicial Council. 1444. Panel members of the regional tribunals other than the chairman shall be appointed by the Chief Justice in consultation with the Regional Coordinating Council for the region and on the advice of the Judicial Council. I say a cursory look at Article 144 clearly indicates that the Chief Justice is not mandated by any provision to officially make a request to the President regarding appointment of justices to the Supreme Court. We read the Article 144 talking about the appointment of justices to the Supreme Court and the Appeals Court. And then the regional tribunals. What I say? Nini nemuno. In none of these articles, any can say Chief Justice now also will request it, just as the Chief Justice wrote, say I request to you the President. No, or say in none of the articles, in none of the law, and can't say Chief Justice whom they also request it, Emma President said in Crofoba Supreme Court Emano. Inti abanesena in the Chief Justice no go to me request Emma President Akufo-Addo say 1-4 judges be meka no ho Supreme Court. Clearly, no, with Yamra. I say clearly, the action taken by the Chief Justice breaches Article 144 of the 1992 Constitution of the Republic of Ghana and meets the threshold of stated misbehavior. Hence, our humble prayer that Her Ladyship, the Chief Justice of Ghana, is removed from office to restore some dignity and public confidence at that high office. And I think that at this point, on my first point I will make it is clear. The Chief Justice Nadia Etiambra. You see, and sometimes I want people to understand. Sometimes, even in this petition, they didn't really go into details the meaning of things like this. Now, if you are to have a very partisan Chief Justice, and then the Chief Justice is able to request, assume a senior Benton among for Mumbra Supreme Court and Mamia. You see, there are a lot of dealings able to me. If you have a very partisan or corrupt Chief Justice, for all you know, yes, she trade. Any year Gigi Sikania de Nkrofa Supreme Court. And I say, Omo Edi Omoba Supreme Court in the Krano. Ye talk Omo allegiance. Because mind you, say it is the Chief Justice who empanels a year judges to a case. It is so no Edi Nkrofa Aba Supreme Court. Na case be aba, no interest wo more. Guess what is going to happen? Guess what is happening to our judiciary? or the nkrofo na wo de omo aba na wo mu owe allegiance to ono no and ebetena case ni so. Then at the end of the day, instead of fairness, e was ye didi asem ne yemfa nkonkodi na asem na ba be ye bubruja. So it is entirely wrong that a chief justice will request say say ni fan crofo bra hama me fan da bi into constitution nim no anka. So basically the chief justice sadia na wo ye no entwa ye. Or say act of incompetence by the chief justice. Or say 9 on 15th October 2024, Honorable Alexander Afenyomarkins invoked the original jurisdiction of the Supreme Court under Article 210B of the 1992 Constitution of the Republic of Ghana. The plaintiff's invocation was activated by a dispute surrounding the filing of nominations by some members of parliament intended to contest the impending December 7, 2024 general elections, either under the ticket of different parties or as independent candidates. Or say, among the issues set down by the plaintiff for determination, emphasis on issue 7 of the purpose of this petition is whether or not the Speaker of Parliament was in breach of the rules of natural justice, that is, odi alterum partem rule, in declaring these 4 parliamentary seats vacant without giving the 4 affected members of parliament a hearing. Into the second case, almost say the jinaso into President Infear Chief Justice the very popular and controversial Afenyomarkins versus Albambagbin case. Now, was it in our opinion, the Chief Justice who presided over the suit to determine whether or not Speaker of Parliament was in breach of the rules of natural justice rather breached same rules in the process of making such determination, which amounts to incompetence. Or say Afenyomarkins edensem ekoto Chief Justice enim na Supreme Court enim. Na Afenyomarkins asem a wode baaye no, de na wo kan say Supreme Court de Albambagbin aye eni. Me pese me bisa say de Albambagbin ye no. Emrama ne ho kwan say wo ye saa ana say emrama ne ho kwan Afenyomarkins mirika wo ba Supreme Court a wo ba besere no no. But I say at the end of the day no, Chief Justice not otena case ni so. No yeah, I mean obviously the Chief Justice on the case no. Emum eba be ma ruling na when tie Albambagbin side of the issue. Now so no wa ma ruling e wo case ni so. Meanwhile Afenyomarkins eba no. Enye de na wo pe no no. And to say our claim is substantiated by the ruling of Afenyo versus Speaker of Parliament and Attorney General, writ number J1/02/2025, dated 12th November 2024, in which the court stated that, notably, the first defendant filed no processes in answer to this action. Our understanding is that at the time of ruling on the above suit, the court had no affidavit from the Speaker of Parliament, being the first defendant. The court also stated that, however, a further step taken 2 days after the issuance of this writ, the first defendant issued a statement captured in the official report on parliamentary debates of October 17th, 2024. In the first 10 pages of the official report, the first defendant elaborately delivered a response to a statement made by the Honorable Minority Leader in which he recognized that he was making a formal response in relation to a matter of significant parliament and constitutional importance. It said that he had been called on to follow precedent and declare vacant the seats of 4 members of parliament pursuant to Article 97(1)(g) and (h) of the Constitution, because certain members of Parliament had taken actions that contravened the provision of Article 97(1)(g) and Article 97(1)(h). The above statement by the court confirms our claim that the court had no affidavit from the first defendant before ruling on the matter. Into I say based on natural and you see, some natural justice argument is the same argument the Chief Justice made when the Chief Justice heard that His Excellency John Dramani Mahama receive petitions a wopese oyino. Mu kind of response na wode bae na waka say oh natural justice ma mi hu nsem ankrofo ne ka fa me ho no na mi hu ana mi nso ma respond natural justice inti ni prako we asem a wo kan say natural justice Chief Justice odi asem no saa time no wontie Albambagbin side no ma Albambagbin side emba meye omo case e wo court ho. Albambagbin was the first defendant no wontie wo mo asem na so the ruling e bae etia Abambagbin. Naturally say Chief Justice no when you sue natural justice and find Juma. It was say our opinion is further substantiated by another statement by the court in the same ruling that both the plaintiff and second defendant filed their statement of case, which in essence aligned with the relief sought by by the plaintiff in the writ with reference to the above statement. There was no legal argument made by the first defendant during court proceedings pursuant to the ruling. So the first defendant filed an application on the same writ on 30th October 2024. In his application, he stated that the Supreme Court breached the rules of natural justice and rule describing the manner for exercising discretion in the orders made on 18th October 2024. In hearing the application ex parte and granting orders to stay execution of the Speaker's ruling pending the resolution of this suit. Interestingly, the court ruled that it is very basic and primarily, it is very basic and primary principle of law that an order of stay of execution must be made on consideration of exceptional circumstances that can affect the parties, which exceptional circumstances include the wreaking of irreparable harm. If